It is also important to note that Regulation 87 of the Election General Regulations provides, and he then goes on to state, that he, as the chairperson, is the one who is then empowered to tally or to verify and tally the results. Again, later on on page 495, he goes on to state, this constitutional mandate, and he's talking about the mandate to tally and verify, this constitutional mandate falls squarely on the chairman of the commission, who is the national returning officer. Again, he repeats that, as gazetted in Gazette Notice number 4956 of the 28th of April 2022. The role of the national returning officer for the presidential election is not a shared responsibility and not subject to plenary discussion of the commission. Very important, because at the end of the day, this is how the second respondent then tallied, verified, and declared the results, but we will get to that later on. He states in the paragraph beginning as the gazetted national returning officer that in the spirit of teamwork, the chairperson involved the commissioners. That is all he did. In the spirit of teamwork, he felt that there was no duty to involve them. All he did was involve the commissioners. And again, later on during my submissions, I will get to that. My learned senior colleagues who submitted before me dwelt in detail on the content of Regulation 83. The content of Regulation 83.2 and Regulation 87.3.1, Regulation 87.3 in its entirety, and the manner in which those two regulations enable the chairperson singularly to tally or to verify and tally results in the presidential election. I do not wish to take any time to go through those two regulations, merely to state that it is my humble and respectful position that those two regulations are inconsistent with the provisions of Article 138(3)(c) of the Constitution, because they enable the result in the presidential election to be verified and tallied in a manner other than envisaged by the Constitution. There is a substantive prayer in the petition to declare those two regulations unconstitutional. And I state for that reason that relief should be granted. Later on in my submissions, I will then make submissions as to the consequence of those regulations being unconstitutional and having then hopefully being declared unconstitutional by this court. The fact that the tallying and verification of the result in the presidential election was done solely by the chairman is laid bare in the provisions of Gazette Notice number 9540 of 8th of August 2022. This again was referred to by my learned senior colleague Mr. Firoz Noroji whilst he's on his feet, and this Gazette Notice is to be found at page 36 of the affidavit sworn by the second respondent and drawn by the firm of my good and learned friend Mr. Eric Gumbo and Associates at page 36 of that affidavit. Mr. Noroji took the court through that affidavit extensively, through that Gazette Notice extensively. I only want to emphasize that before the election, the chairman of the commission is clear that it is he who will tally, who will verify and tally the results. And for some reason, the chairman has the chairman of the IEBC had the propensity to publish Gazette Notices even where he didn't need to, because there was no need, there is no statutory basis or regulatory basis or even constitutional basis for gazetting the result pathway. But he went ahead and did it. And it is clear, and I submit it is admitted by the chairman of the IEBC that he exclusively, to the exclusion of the rest of the commissioners of the IEBC, tallied and verified the result for the presidential election. So as to determine conclusively that the tallying and verification was done exclusively by the chairman, it is again important to ask the question, where were the other commissioners? Where was the rest of the IEBC as the chairman was tallying and verifying the results? Again, I wish to refer you to the same affidavit that I have, the affidavit sworn by the chairman and drawn by the firm of G&A Advocates on the 26th of August this year. And it starts from the second paragraph. He states in the second paragraph that in my capacity as the chairperson of the commission, I was the returning officer of the presidential election. He then goes on later on in the affidavit at paragraph 45 to state that for the proper management of roles at the tallying center of the presidential elections, I had designated in writing specific roles to each of the commissioners and other commission staff. Annexed here to as WWC 9 is a bundle containing the said communication. Again, this bundle and this communication is important, members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July addressed to the vice chairperson Juliana Cherere and Commissioner Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, Team Leader. Commissioner Boya Molu, Alternate Team Leader. And their roles are set out there. Terms of reference of your appointment provide liaison between the Presidential Returning Officer, who is himself, and the National Communication Center, preparing periodic briefs for the Presidential Returning Officer to address the media, briefing the Presidential Returning Officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the Welfare and Security Team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Guliye and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the IBC. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the IEBC was done by Professor Abdi Gulie and Marjan Hussein Marjan, and not by the IEBC. The tallying process continues, unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question, how does that process then end? That process ends as set out in paragraphs, again the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. He deposed, shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Marjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Gulie and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words, and I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer, or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether IBC carried out verification, tallying, and declaration of the results in accordance with Article 138(3)(c) and 138(10), I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5.1 of the IEBC Act would disclose that those 3 gentlemen, however eminent, are not the IEBC. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. With tremendous respect to the chairman, the issue of his ability to tally and verify on his own was not an issue in Raila 2017. And with the clear provisions of the Constitution, in Article 138(3)(c), there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138(2) of the Constitution. Article 138(2) of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election by dint of Article 138(2) is by 290 returning officers. The notice that they were required to publish under Regulation 12(2) was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the gazette notice is the gazette notice, I think it is the 22nd or 28th of May. He gazetted himself as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue, and I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the IEBC has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The constitution provided that by-election be held within 90 days. That by-election was not held until the 20th of December 2000, or not 2000, 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had, assumed certain roles and capacities to himself. I wish to refer to the affidavit of ULEANA Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the last, to annexure JC12. That annexure is correspondence, it is internal memos within the commission. The first one is signed by the 4 commissioners, and it is a request for a special meeting whose agenda is to deliberate the commission's position in light of the presidential elections petition filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexure JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the commission? Is that a chairman acting constitutionally responsibly? The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Piece of legislation is a nullity. In the brief time that I have left to answer the ground number 7, it is impossible to tell whether the returned candidate garnered 50% plus 1, because the process by which that finding would have been made did not take place constitutionally. The election having been conducted as it was, there is no result. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the IEBC. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did, and for those reasons, it is my humble request that all the prayers that are sought in petition number 2 of 2022 be granted.
Thank you, Council. Next. Yes.
If may please, my lords and my ladies, I start by saying that election is a process. I'm Otieno Willis, appearing for petitioner number 4. Election is a process that ends upon the determination of the true wish of the voter. And when that process is unconstitutional, it is not enough to throw numbers that are arrived at through an unconstitutional way to assert that that is the true will of the voter. The first issue I wish to address, my lords and my ladies, is issue number 6. And issue number 6, core to it, is Article 138(3)(c) of the Constitution, which vests upon the IEBC the duty to tally and verify results from all polling stations and to declare the result. I want the court to take note of the last part of Article 138(3)(c). The IEBC shall tally and verify the count and declare the result, not the results. Results is the numbers. Result, without an S, is the outcome. And I want the court to notice that 138(3)(c) is a responsibility on the commission, not on the chairman. So the first declaration of the results of the verified and the tallied counts is made by IEBC as a commission. Then the chairperson, again, the word of the Constitution used is the chairperson in Article 138(10) shall now proceed to formally declare the results and issue the certificate. My lord and my ladies, Article 138(3) sets out a 4-tier process. Tier 1 is the polling station. Tier 2 is the constituency. Tier 3 is the National Tallying Center, in brackets IEBC Commission. And Tier 4 is the chairperson. Tier 2 cannot function without Tier 1. A constituency cannot function if polling fails at the polling station. A returning officer cannot go to a polling station and make a declaration of the results of that polling station. It's not his function. The IEBC as a commission cannot go to a constituency and fill Form 34B for a particular constituency. If they do so, they failed it. Similarly, the chairperson cannot move from Tier 4 and go to Tier 3 and purport to verify and tally the votes, the counts, and make a declaration. Each tier must perform its function. It is now tried that under Article 81, elections must be conducted by an independent body. The presidential elections whose results we are disputing were conducted by an independent individual, not a body. Because if it was a body, I would not have been served with documents from commissioners confirming they did not participate in the verification and tallying of the count. A majority of the commissioners, IEBC in their replying affidavits served upon me, has confirmed they did not tally and verify those results. My lords and my ladies, I wish to state Chapter 15 of our Constitution establishes constitutional commissions and independent offices. Where the Constitution desired a function to be performed by an individual, it established an independent office. The Office of Auditor General, the Office of Controller of Budget. But where it desired a function to be performed by a commission, it established an independent commission. The Office of Election Management Body is a commission. It is not established as a chief elections officer as an independent office, as Wafula Chebukati seeks to run the commission. My lords, if the people of Kenya desired to have an individual, they would have simply reverted back to 1988 when we had a supervisor of elections. I will not go back into what has been submitted, but only to add on that point that where a commission has been properly constituted and the number is set as an odd number, the Constitution and the law presupposes there may be dissent. And the oddity of the number is to make sure that ultimately a decision will be arrived at. In this particular case, the oddity of the numbers led to a decision of the commission. And a majority of those commissioners have told us in their affidavits that they did not carry out a tally and verification of the results. Tier 3 failed. Confirmed. Let us go to the state of mind of Mr. Wafula Chebukati on the 15th when he was conducting this function. Just to confirm to you that he did it himself. In page 12 of volume 1 of my documents is a statement dated 17th of August by Wafula Chebukati, in which he says that it was his sole responsibility and that the commissioners had no role in that process. That was his state of mind. But the same person, when he comes to court in his replying affidavit at paragraph 75, 76, 84, 85, he turns around and says the commission in a collegiate manner arrived at a decision. Why is he lying? If on the 17th he has told us it was his sole responsibility. When he comes to court now, he says the verification was done by everybody. And it's important that I point out in the replying affidavit by William Ruto at paragraph 16 and 17, he also says that it is the sole responsibility of the chairperson to verify and to tally the results. That was their state of mind. But we are submitting it is not the law. The law is everybody must conduct it. These issues which we are raising were canvassed in the minor KI case. Hele Khalifa, the petitioner number 1 in this petition, was a petitioner there. And the court said the IEBC, as opposed to its chairperson, upon receipt of prescribed forms containing tablet results for the election of president, electronically transmitted to it from the near 45 polling stations, is required to tally and verify the results received. That was the law in minor KI. And they go further to say the architecture of our laws is that the power to tally and verify cannot be vested in an individual. Supreme Court Raila Odinga 2017, the court said in paragraph 292, the failure by the first respondent to verify the results in consultation with the second respondent, IEBC and the chairman, failing to act together in concert, meant that it went against Article 138(3)(c). That was binding. To drive this point home, my lords and my ladies, taking into account those two decisions, the number of IEBC commissioners are 7 plus the chairperson. The number of Supreme Court judges are 7 plus the Chief Justice. If, as been...
Counsel,
yes.
Do I understand you to be comparing the Supreme Court, its architecture, and the IEBC?
No. I wanted to give an example. try to be very careful and not extreme. I just use the number of 7. That in terms of 7, the Supreme Court sits as a full bench when constituted. And the rules on arriving at a decision is by majority. And there have been even instances when the Chief Justice of this court has been on a minority. And we never saw a Chief Justice walking out there saying, my minority decision is the decision of the Supreme Court of Kenya. In the instance petition, we have the chairman and Gulie and Mr. Bolu walking out saying, our minority decision is the decision of the IEBC. How absurd can it be? And to buttress that point, Mr. Nyamodi has clarified what roles were given to the commissioners as opposed to telling. The roles given, for example, to judges are known to adjudicate over matters. If it were to happen, and I know it can never happen, that the Chief Justice assigns judges some to go and receive advocates, some to go and receive VIPs, some to go and receive the media, then the Chief Justice remains with only 2 other judges, and they make a decision and tell the people of Kenya, this is the decision of the Supreme Court of Kenya. How absurd will it be? That is what transpired in this particular case. Commissioners were relegated outside their core functions, and the function performed by an individual, what I call a minority of the IEBC. That was never the intention of the law. On the technological aspect, as I move to summarize, I want to refer, my lords and my ladies, that's issue number 1, on the qualitative test of the technology. IEBC, under the Elections General Technology Regulations, conducted an independent audit of the biometric voter register. This is what your auditors said. At page 32, volume 1 of my bundle of documents, the KPMG report found that 481,711 persons were not qualified to be on the register, but they were on the register. Duplicates. One person has several entries. If this number was below the margin of victory, it will be insignificant. The start of an election process is the voter register. It must be a very clean document. In this case, they started the race with a register by their own audit as at the 16th of June. The register that was gazetted on the 20th of June, that register had 481,711 persons who were not supposed to be there. Duplicates, several entries. The margin of victory by William Ruto passes 50% plus 1 is less than 70,000 within this margin. The margin of victory by which is declared more than Raila Odinga, 200,000, again less than this. So the universe of the elections was already compromised ab initio, and the number by which it is compromised could affect and did affect the results. To use my Supreme Court example, I will say, if all the judges were biometrically registered, we know there are 7 judges, but we do a biometrics audit, we find there are 9 voters in that register. Would we say that that register is authentic if they are to vote on an issue, and then the return is 4-3, and yet the register had 9 people? Would we say that only those who are legitimately qualified to vote participated? I would say not. In page 36 of my volume 1, the audit report finds that 638,814 entries were noted to be null IDs. You have registered voters on the register who don't have ID numbers. Null. That is the quality of your election document. And at page 37, the auditors find that there are generic users who cannot be attached to anyone, generic users of the biometric voter register system who cannot be attributed to anyone. But more importantly, the auditors found that there were 14 non-returning officers, users, accounts that had been granted voter access privileges on the identity data management system. Non-users, some of them are referred to as Embakasi South clerks. People who had access to the system and they were able to make changes on the persons who are supposed to be on the register. Non-authorized users, their own document. At page 39, audit report finds that there are users who are not gazetted returning officers that have access to the database. It is important that we note this.
That these persons, because they had the IDs of were registered voters. That is also a solemn process, because then they confirm, out of all this, were there any other voters that were identified to the determination whether the 50+1 had been attained. They were not allowed to do that. And they requested, it's not that because there was an oversight, they requested and the chairman declined. So this transparency at the National Tallying Center is critical, because as a commission, you have to come and defend the process from the Gazette notice that was issued in January of 2022 to the final declaration. And the fact that the chairman was stubborn is a question, as set out in these 4 affidavits, is that he has contempt not only for his fellow commissioners, but also for the voters and also for the people of this republic, as well as the institutions, because that's exactly what he was told as the chairman, not him as a person, in Maina Kiai, that the chairman of IEBC does not have that role singularly. That is a role vested in the commission. Failure to adhere to a decision that is binding in the commission and the chairman of the commission is contempt not only of the constitution, but of the institutions, of the judicial institutions that have said this over and over again. And let me go back to the lack of transparency in the process. When you look at the affidavit, which is the most detailed of the vice chairperson of the commission, there's lack of transparency regarding even when the ballot papers came to this country. The chairman calls it the vice chairperson the night before the ballot papers are to land here, and tells, you are aware that tomorrow we're getting ballot papers. The other commissioners were not aware. This is part of the critical process that was meant to be undertaken by the commission. So transparency is just not at the tallying center, it's about the whole process. But if you look at paragraph 8 of the vice chairman of the commission, ULEANA, she says, when it came to the issues raised about the voter register that were being addressed in one of the petitions, serious issues have been raised by KPMG. And so that required prompt, because this process was already late, it required a plenary decision on how to address the shortcomings and the lack of integrity of the data in that voter register. The vice chair says they were excluded from that process by the chairperson. So if there was any problem with the voter register, it was meant to be addressed by the commissioners, because they take ownership of the voter register. They were excluded. He made the decision on how to implement the decision and even what to disclose to the public. So these are the processes we're saying. Transparency and accountability in the whole process, and Article 81 and 86 is just not about the final product that appears on the tally. It's about what the commissioners are meant to do. And lastly, when you look at the affidavit of Commissioner Justice Nyang'ara, if anyone was to be given access to the voter identification, the result transmission system, or the back end, the commissioners needed to know we are giving the following persons access and the following rights, so that if there's any query, they can answer on behalf of the commission. That information was kept away by the commissioners, from the commissioners. In fact, the commissioner in charge of that process. Lack of accountability and lack of transparency. And then these 4 commissioners who are being vilified are expected to come and stand behind the chairman and take ownership of such a process that has so many questions and then confirm that a person has been declared the president without following due process under the Constitution. They took an oath, and they have a responsibility and a constitutional obligation to the voters and to the people of Kenya not to take part in such a process. And that's what they did on the day of 15th. And the day of 15th is important because if it was the last day, there could have been an explanation as to why the chairman was in a hurry. There was one more extra day. Why was the chairman in a hurry while the choir was singing, the country was peaceful? He had one more day to ensure that the whole process was undertaken in a manner contemplated under the Constitution. And so, my lords, my ladies and my lords, we submit that these 4 commissioners, and although they have taken a position here and they've now been they've been sued as respondents, had every right not to give a seal of approval to that process that was not verifiable, it was not accountable, and had not been undertaken in conformity with the Constitution. They respect the work that all the staff at the Commission had done, but they were betrayed by the chairman. Thank you, Chief Justice and Judges of the Supreme Court.
Thank you very much. It is now time for the judges to ask any questions or clarifications in regard to the submissions we have had today. We expect the answers when you will be making a rejoinder. We are not expecting the answers now. It's when you're making the rejoinder. I will start with the Honorable Justice Ogo.
Thank you, Madam President. I have 3 very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates that I go to the voting or polling station to vote for an MCA, or is it called MC? That people go to vote for a senator but not the other positions. Do you have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. Were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Jenda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renara.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have 3 questions, 4 I think, but very short ones. The first is to Senior Counsel Philip Murgo. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect? Because you addressed us, I think you didn't connect the JPEG to PDF, and then you said CDF.
I will, but I'd just like to clarify that that was a mistake on my part.
Okay. Correct. But just clarify when you answer, so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number 2, Mr. Arwa, and this could also go to the other counsel appearing for the commissioners. You've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your plans in public, reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that this is an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to counsel, the meeting they called? Why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there are issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulier was attacked, we could announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Firoz Moroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone will ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Counsel.
Yes, let me just take up from where Justice Lenaula has with Mr. Ndega. Mr. Ndega, if you look at Article 38.2, every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typo, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since she will answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate, and what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election, or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for, or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Orengo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgur, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So, to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans do not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions, and the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila Odinga and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50+1. And after the inquiry, you would like that after the scrutiny election and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners, that's the 2 petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your agenda. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that you have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We have one justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us, justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that if an election is to be ordered to be done now, yet one of the reliefs you're seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he is perpetrated, that he is not fit to carry out that exercise, to be in charge of such elections. Our Constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are the serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we have never contemplated, and I don't wish to think about it. Finally, yeah, actually that is all, because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Team Orengo, my concern is, and actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result? My second concern is from 34A. Maina Kiai told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A
photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, which ought to have followed the first one before this PDF language, is what is to be done as a corrective measure against the chair of this dysfunctional commission. And is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare a winner? Are the figures, in the event that we arrive at figures that show that either the current president-elect has more votes than others, and or the petitioner in petition number 5 in fact has more numbers, what are we to do? Are we still to declare, irrespective of all the other processes having been impugned as you have submitted to us today? If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the read petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot, should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitutional office order. Under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, and my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offenses. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomas. We really want to understand, like the Vice President is asking, when did the commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibo Mungai. And I want you to answer this and tell us how you know that IBC did not make arrangements for certain categories of people to vote, especially the IBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. You know, because this seems quite subjective, so you needed to explain more that you know 700,000 people did not vote because IBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I upgrade on your last question? Section 6 of the IBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order remove of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
Information, Madam Chief Justice. There is still an issue arising out of the scrutiny. I am told I would like my learned junior to explain, because he's the one covering the technical issue of the scrutiny.
Good evening, my lady, the Chief Justice and the Honorable Judges of the Supreme Court. My name is Eric Gumbo. We've had interaction with my colleagues who are handling the scrutiny, and they give us the indication that there's been very good progress so far. But there's one specific issue which they would want to get clarification from this court on, that arises from order number 2. Specifically, the use of the word forensic image. Now, the applicants appear to be interpreting that to mean an opportunity to get the image of the entire server. Now, that is causing a bit of a concern, because then it means if they have the image of the server, technically they'll have gotten access to everything that certainly is contained in that server. It means that that order will be so far-reaching that after that event, it may not be possible for the IEBC to use that server again. It then particularly concerns the Commission, because if perchance there was an order for a repeat election and you don't have that infrastructure, it then means that that election may not be conducted. The other concern is the potential breaches that might be in relation to third-party licenses that are contained, and so therefore it really is important that we get clarity on that question so that then the exercise can proceed smoothly. I am most obliged.
Yes, with your permission, Madam Chief Justice, ladies. I raise because after we broke off over lunchtime, I personally went to the IEBC offices, 21st floor, where the exercise was going on. And I'm sorry, but I don't think what my learned friend has said is exactly what was going on. First, the team that was sent by this court to supervise did come up with what was an implementation matrix and laid it out. I think this was done yesterday. And what I learned is the biggest problem that has been going the whole day are arguments about this implementation matrix. And as by the time I left at 3 o'clock, nothing had happened. And even some of the simplest issues as giving copies of the technology system security policy had not happened. So what I met is an argument between technical computer people about what they should comply or not comply with, about what forensic, for instance, the issue of the forensic image is not correct, that the demand was for an image of the entire server. In fact, what I meant had been agreed on was that the part of the server that was supposed to be forensically imaged was going to be cloned so that there's no access to and that had also been agreed on. But when it came to implementing it, there were always new arguments. And in my estimation, what I found is that there is nobody at IEBC who this order is directed at, who is responsible for ensuring that these matters are done. The CEO of IEBC was there,
The director of ICT was there. There were 2 or 3 lawyers from IEBC and a host of other technical people. And all that was happening was arguments happening between one team and another team. The CEO says this, but he doesn't talk, so other tech people come, argue with the people from the political parties. That is the confusion that is going on. And therefore, unless this court addresses its order at a specific person, who then can come in case there is doubt as to what these terms mean, can themselves come for clarification, then that confusion will go on. But either way, we did try to sort out the problems that were there. I left at about 4 o'clock, the process now starting. The advice I give to the team is, let us first see what happens in the several hours, and then they will say what is it they are not getting, and we can report that to court. I will be going there after this to find out how far that has gone. I still feel very strongly that this court needs to make somebody from IEBC responsible for the implementation of this order. Thank you.
My Lord, sorry. Without appearing to belabor the point, sorry.
Sorry, yeah, being given an example of one of the issues that arose is because there's also an argument going on as to how many servers are involved. There was talk of only accessing one server, then there's a whole range of technical arguments as to how many servers are involved in an RTS and how many should be shown. Team is saying that there are about 8 servers involved, that they've only gotten access to one, that they're not getting access to the other 7. There's nobody at IEBC who takes responsibility to answer that question, so nothing gets done. Thank you.
Sorry, my lady. Sorry, my lady and my ladies and my lords. Without appearing to want to belabor that point too much, I think when we got back after the short break that the court took, Justice Lenola did indicate that there was fairly good progress in all the fronts, both in for the House and in anniversary. So it certainly cannot be true what counsel is saying, that there has not been progress, because then that would impute that counsel is even saying that the court is not saying what is happening. We have gotten very clear indications that there's been, there are 4 compliance items that were raised. There were 4 compliance items that were raised. Out of those 4, item number 2 has been resolved, item number 3 has been resolved, item number 4 has been resolved. That is the current update that we are getting from our team. The only item that is outstanding is the question of forensic image. And I think there's substantially good progress. It is not accurate to report that there's no progress. We have our director of ICT who's personally taking charge there and is the one who's updating us on what is happening. I think if we could get a clarification in relation to what that forensic image is, then we will be able to complete the exercise. I'm most obliged.
Thank you, Councillor. I think from what we understood when we took the break for lunch and when we came back, the issue of order number 2 had been resolved by the question of cloning as opposed to the security question of forensically imaging the server. So what we gathered, and that's what I said when we came from lunch, was that there is progress. Let us revisit it later today after we leave here. But as far as we were concerned, the resolution was that they'll do some cloning, and then any concerns that this team would have would then be presented to us tomorrow, having also gotten a report from our team. But at the time we came, there was good progress, and that's what Mr. Gumbo is saying, so far as we knew from our team out there. So perhaps, CJ, the way to go, let us go back ourselves, perhaps get our report from our team, and should there be any need for a direction tonight, we could do that remotely. And if not, then we give a report in the morning, because we gathered that the progress was immense and that something would be perhaps actually finalized tonight. I think that's the best way to go, instead of us going back and forth. And we don't have a report from our team. So would you allow us to do that? Then we come back to you. Thank you, CJ.
Thank you very much. I think fatigue has settled until even my own gown has tethered me to the seat. I cannot move. But with that clarification, and just to remind ourselves that our team is led by the registrar of the court, who is going to make a report to this court. Council Paul Mwangi, I think what you are making to us was a kind of a report. So let us see how we can cooperate and get the best evidence that can assist the court. With that, allow me to wish all of you a good night and look forward to seeing you here tomorrow at 9 when we start the questions will be answered in the agenda. Yes, have a very good night.